Have you ever wondered what happens when your tenants just cannot seem to get along with their neighbors, perhaps over noise, parking, or shared spaces? It is a common challenge that can create stress for everyone involved, leaving you to ponder your role as a property owner. Yes, landlords can indeed provide dispute resolution for neighbors, but it is important to understand the scope and boundaries of that involvement. While you are not generally obligated to mediate every personal disagreement between tenants or with external neighbors, there are specific situations where your intervention is not only appropriate but also beneficial for your property. The primary reason landlords get involved is rooted in the lease agreement and the principle of quiet enjoyment. Every tenant has a right to quiet enjoyment of their rented space, meaning they should not be subjected to excessive disturbances. If a neighbor's actions, whether another tenant or someone outside the property, violate lease terms like noise clauses, property rules, or local ordinances, then it becomes a landlord's responsibility to address the issue. Your role is not to pick sides in a personal feud, but to ensure that the terms of the lease and the living environment are upheld for all residents. If you find yourself in this situation, a good first step is to review the lease agreement with both parties to identify any violated clauses. You can then facilitate a structured conversation, acting as a neutral party to help tenants articulate their concerns and propose solutions. Sometimes, a simple reminder of community guidelines or an informal meeting can de-escalate tensions. If the issues persist, you might suggest formal mediation services, which are often available through local housing authorities or community centers. Documenting all complaints and actions taken is also crucial for your records. It is also helpful to understand the concept of a nuisance clause in a lease. This specifies that tenants must not engage in activities that disturb the peace, comfort, or safety of other residents or neighbors. Violations of such clauses can justify landlord intervention. Similarly, distinguishing between a direct landlord-tenant dispute and a tenant-to-tenant or neighbor-to-neighbor conflict is key. While you might mediate the latter, your legal obligations are primarily focused on maintaining the property and upholding lease terms. By understanding when and how to get involved, you can effectively manage neighbor disputes, ensure a harmonious living environment for your tenants, and protect the value and reputation of your rental property. Your goal is to guide tenants towards respectful coexistence while firmly enforcing the rules designed to benefit everyone.